Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. In this case, we are going to study a case study. Actually, we are going for a case study on the default bail, that is 167 CRPC, on the aspect of filing of incomplete charge sheet, or also filing of charge sheet without sanction. If the charge sheet is filed without sanction, can it be termed as a full-fledged charge sheet or not, and whether bail can be given or not? This is what is discussed in the case of Jadgebar Singh alias Jasbir Singh and others versus National Investigation Agency and others in Criminal Appeal number 1011 by 2023, decided on yesterday, 1/5/2023 by bench of Honorable Chief Justice of India and J.B. Parthiwala, in which the Honorable Supreme Court of India held that mere filing of the charge sheet without sanction from the authority does not authorize the accused person to get the default bail. When the police file the charge sheet, means they have filed the charge sheet. Maybe incomplete charge sheet, maybe without authority, maybe they may have to comply with some instructions, but charge sheet is a charge sheet. Now, let us know the provisions of law also. Normally, frequently discuss the provisions of law. So, whenever FIR is registered, 154 CRPC. Whenever a person is arrested, normally the investigation is to be completed within 24 hours. If it is not, then you have to produce the accused before the magistrate for judicial custody. That is envisaged under section 167 clause 1 of the CRPC. If the investigation is not completed within the stipulated time of 60 days, 90 days, 180 days, because we are going to discuss UPA case, unlawful activities prevention case. So 180 days. Then if the charge sheet is not filed within the specified time, yes, the accused has got a right to get default bail under section 167 clause 2 CRPC. And normally the police, they have to complete investigation and file the final report under section 173 CRPC. These are the general provisions. Now, to avoid the so-called 90 days or 180 days time, yes, the police will file the charge sheet in the court of law. And please remember, the charge sheet is not immediately numbered. The court will raise certain objections. What are the documents? Whether the document copies are supplied to the copies are attested to be supplied to the accused or not. Like that, they will ask so many questions. What is the opinion? Like that. So, mere filing of charge sheet is sufficient. Here, the important point is the police filed the charge sheet within the stipulated time, but they did not get an authority because because it is this is unlawful activities case. Even then, it is a charge sheet. So the accused has no chance to get the so-called default bail. Coming to the facts of the case. So, Supreme Court, right, on 2/6/2010 at about 4:50 a.m., when a team of police officers were patrolling and checking vehicles in Punjab, then two boys who came on a motorcycle, they tried to escape. They tried to whisk away from the police. Of course, the police caught them and they have recovered so many things. Ultimately, they were found to be having the so-called involved in the activities, unlawful activities, and they are liable for punishment under the UPA Act. So, case of 120B IPC, that is criminal conspiracy, sections 17, 18, 18B and 20 of the UPA Act. And also they were found in possession of some weapons. Therefore, section 4 and 5 of the Explosive Substance Act was also booked against them. So, for prosecuting a person under ES Act, definitely the sanction from the collector is necessary. So the police witnesses have to produce them to the court within 180 days. They have to complete investigation. They file the charge sheet, but the sanctioning authority is the sanction letter is not there. No doubt they have presented the representation. They have presented the case file also to the collector, but there is some administrative delay. The other party, they took advantage of the same, and they requested the honorable right from the lower court. They have been requesting. Now the matter has come to the Supreme Court. They stated that, no doubt, Your Honor, they filed the loosely knitted charge sheet. They filed the charge sheet, that's all. It doesn't have any authority from the collector. If the authority is not there, how can you call it as a full-fledged charge sheet? So it's not a full-fledged charge sheet. Therefore, our client, that is accused, has got a right to get the so-called default bail. But Supreme Court said that the charge sheet is filed in time. No doubt. No merit in saying that there is no sanction. Sanction they will get later. What is there? If you raise objection, they have to. If not, the charge sheet will not be numbered. When once the charge sheet is filed, normally the documents are submitted as per 173 crpc. If at all any other documents are necessary, yes, we can requisition them also. So this is what is held by the Honorable Supreme Court of India. So in this case, our personal case, that is where we are involved, in crpc case. So please refer to that case also. Chaganti Naidamma versus State of AP, where the period of filing of the charge sheet, whether it is on 90th day or 91st day, a lot of discussion was there. Even Supreme Court held that yes, the charge sheet filed on the particular day is on 90th day. Police are correct. So likewise, so here this is a little bit different case. Even though it is filed without the so-called sanction, it is a charge sheet. So the accuser cannot go for bail. Here there was a particular case where already he was granted bail, but he could not come out because of the UPA sections. Is a different thing. But what you have to learn from this case is that a charge sheet filed even without sanction orders from the collector under Section 5 of the ES Act can be treated as charge sheet. If you know this much, it is sufficient. Thank you.